How you doing, sir?
I'm fine. Has Mr. Strickland spoken? Has he spoken to his attorney yet?
No, he hasn't.
Okay. She's in a breakout room with another person, and as soon as she's done with that person, I'll put you in the breakout room with Mr. Strickland. So it'll be a few minutes, okay?
Okay, sir. I just want to let you know he's not consenting to do a video arraignment.
So what is he consenting to do?
I'm getting him his paper. Is there any paper clips or anything?
Oh my God.
Yeah.
Yeah.
This is the court, sir.
I don't consent to the thing. I'm asking why they can't bring me forward.
Okay, hold on. Does he want to speak to an attorney first?
Yeah, well, let's have him speak to an attorney first. You have to speak to an attorney. You have to.
Hold on. Mr. Strickland? Mr. Strickland, can you hear me?
I don't need an attorney.
This is the judge.
Okay, Mr. Strickland,
Open the door.
can you hear me?
Can you hear
Oh,
me?
you don't want to hear me.
Sir, can you hear me?
What?
Mr. Strickland, this is
All right.
Magistrate William Burden. Good morning. I'm going to ask you a few questions. Do you want to speak with an attorney?
Who are you speaking with? The flesh and blood man with a name? Because that's what I'm trying to find out right now, Judge. Who are you speaking with? The name entity or the flesh and blood?
I'm speaking to the person that's talking to me right now.
I am executive of the name entity. That's who you're talking to right now. Do you understand? I am the executor of the name entity. I demand to be released on my own recognizance. I have right here, Judge. You see this, Judge? And then I also have a UCC1 in the name entity. So y'all trying to run a lien on the name.
Notice what he's waving around? A UCC1 financing statement. Sovereign citizens love this move. They think by filing commercial code documents, they somehow own their legal name like a brand and can declare independence from the court. The truth? The Uniform Commercial Code has nothing to do with criminal law. It's about contracts and secured transactions, not jail time. Waving it in front of a magistrate is like showing your gym membership card at airport security. Completely irrelevant. Judges usually just nod politely before shutting it down.
Secretary of State, just
Okay. Sir?
this right here, Lincoln, to the flesh and blood and or the name
Sir? Sir?
I'm trying to ask.
Sir, whether I'm talking to the flesh and blood or name entity, I'm talking to both of y'all at the same time. Do either of you want to speak to an attorney?
No, sir.
Okay.
And I don't consent to an attorney. I don't consent to be in no hearing.
Sir, I just asked you one question. I just need one answer.
And I don't consent.
Okay, I know that.
So who are you
Okay.
speaking with? The flesh and blood man or the name entity?
I'm speaking to both of y'all. I'm speaking to both of y'all at the same time. How about that?
You can't.
Now, Sir, I know you want me to release you.
Here it
Are
is.
you gonna let me talk?
Here. You
Are
see
you
it?
gonna let me talk? Sir,
Sir?
are you gonna let me talk? I got some questions for you.
I'm here without consent.
Put the paperwork down,
Don't
sir.
consent to this.
I know you don't consent to this. You want the court to release you, is that correct?
Yeah.
Want to release you, the entity, or the person in the flesh? Which one?
Flesh and blood man. I own the entity, so it's going to be released anyway.
All right, now.
For UCC1.
What you just heard is judicial patience at its finest. Instead of arguing about metaphysics, flesh and blood versus corporate entities, the judge keeps it simple. I'm talking to you, the person in front of me. That's it. No loophole, no jargon. This is why sovereign citizen tactics always collapse. The legal system runs on recognized statutes, not fringe word games. The judge knows if he engages too much, he legitimizes the nonsense. So he diffuses it with calm authority, a masterclass in courtroom control.
Hi,
Hi, can you state your name for the record, please?
Shannon Phillips.
Okay, thank you very much. So today is the date and time set for an arraignment in this matter. What I have here is a citation from May 27th of 2024 that charges that on or about that date you did operate a motor vehicle on E-Course Road at or near Harris Road with improper plates. It says that the plate did not come back to the vehicle that it was on. That is a misdemeanor with a maximum penalty of up to 90 days in jail, a $500 fine with court costs, or both. Do you understand all that?
No, I do not understand.
Okay. So let me clarify. When I ask if you understand, what I want to know is, do you know now what you are being charged with, whether or not you agree with it?
No, I do not agree with it, and I filed
Okay.
paperwork to the court
Yes.
expressing that.
Okay, and I'm cutting you off for a second because I'm not asking if you agree with it. I'm just asking. I have explained that you're being charged with having improper plates. Do you understand that?
Here comes the paperwork parade. Sovereign citizens almost always come armed with binders, filings, and notarized nonsense, as if a stack of papers can magically erase charges. But paperwork without legal grounding is just clutter. Think of it this way. If I wrote "I am immune from traffic tickets" on a sticky note, would that hold up in court? Of course not. Yet sovereign citizens treat their self-made documents like holy shields. Ironically, the more they waive them, the more they look unprepared for real legal defense.
Court, you have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings. You do not have to disclose citizenship status to the court, but you do have the right to consult with an attorney to see if these proceedings would have any effect on your citizenship status. If that does not apply to you, then do not worry about it. So, do you wish to have the public defender speak on your behalf?
No.
Okay. In regards to the misdemeanor charge against you, how are you pleading at this time? Or are you standing mute?
Standing mute.
Okay. I am going to set this for a...
Ma'am,
Yes.
this has been long and drawn out since, May. I don't even have that vehicle anymore. Unfortunately, I've had to buy 2 vehicles since that vehicle. Not to mention how aggressive and threatening your officers was when they approached my vehicle.
Watch closely here. The judge is practically begging for one straight answer. Do you want a lawyer? That's it. And still, the defendant insists on not consenting. This is where courtroom patience starts to crack. Because arraignment is supposed to be quick. Charges, rights, plea, done. Instead, it's dragging on because of one man's refusal to play by the rules. The irony? By rejecting the process, he's blocking the very thing he wants. Release. It's like refusing to unlock your front door while complaining you're stuck inside.
Okay. Before you continue, couple of things. One, I will note that the officers are not court employees, so they are not the court's officers. What I am going to do, because it is the next step in this process, is set you for a pretrial. Okay? The purpose of the hearing today is to make sure that you know what you're being charged with and what the potential penalties are. The next step is a pretrial, which is where you will get to discuss with the judge more of what happened that day, and if you have evidence, then you can bring it up then. Your pretrial is being scheduled for November 27th.
Just a waste of time. 11/27.
Correct. This year, so that's 11/27/2024. That will be at 9 in the morning over Zoom before Judge Washington. Because of your appearance here today, I am recalling the bench warrant that issued for your arrest on October 9th. That bench warrant had issued because of failure to appear for a number of arraignment dates that were set.
But I was there, and I have proof of that as well. I was on the hearing. It did the same thing it was doing now, saying that the host was there and would let me in. But I sat there for over like 2 hours.
Finally, the magistrate makes the only move possible. Push it to another day. Courts don't grind to a halt just because one person refuses to cooperate. They simply reschedule, and the defendant sits in limbo until he plays ball. This is a reminder of how resilient the justice system is. Sovereign citizens can delay the inevitable, but they can't stop it. The system always waits them out. At this point, who do you think is suffering more? The court or the defendant stuck behind bars until he gives a real answer?
To be clear, the bench warrant is being recalled, so that is going away.
Thank you.
The court is setting a personal recognizance bond, so basically you're promising to appear for the next court date. Again, that's November 27th. I will note that sometimes, depending on the size of the docket, it can take a long time. And I think my arraignment docket last Wednesday took 3.5 hours. So it can take a long time. So long as you're seeing the message that the Zoom is still going on and that the host knows you're there and can let you in, then as much as it is not a whole lot of fun, you should wait. Okay? Okay. So, do you have any questions right now?
Not at the moment. I don't believe so, no.
Okay, thank you. So, your next court date again, November 27th, 2024, 9 in the morning over...
Now round 2. A different courtroom, same playbook. This time, it's a woman facing a misdemeanor for improper plates. At first, she's calmer, but listen carefully. She claims she doesn't understand the charges. That's sovereign citizen code for refusing jurisdiction. But here's the kicker. The court doesn't need her agreement, just her acknowledgement. Judges handle this by separating understanding from consent. You don't have to agree, you just need to know what you're charged with. And just like that, her tactic crumbles before it even starts.
Paul Barnett on behalf of the township.
Assistant Public Defender Davi Lieba on behalf of Ms. Philp. Your Honor, when I spent to speak to Ms. Philp yesterday, she advised me that she did not want to be represented by the Public Defender's Office. Ms. Philp, could you say your name, ma'am?
Ms. Phillips, please state your name.
Yes. Shannon Phillips, the natural woman. On the
Okay,
record and for the record, and let the record reflect. Can you guys hear me? It's saying I have an unstable connection. Okay. Just making sure.
On October 9th, defendant was found in contempt of court. So that still stands, ma'am. You can choose not to have counsel if you want, but you need to understand that.
Standing mute, another sovereign citizen favorite. Legally, it's allowed, and the court automatically enters a not guilty plea. But in Solvsit world, it's their way of saying, I refuse to validate this court. Here's the problem. The process moves forward anyway. It doesn't delay trial, it doesn't cancel charges, it doesn't erase fines. The court has built-in safeguards against obstruction. To the judge, this is business as usual. To the defendant, it feels like defiance. But in reality, it's just compliance disguised as rebellion.
In a way that makes me feel comfortable that you don't understand that you understand the laws of the state.
You all are speaking legalese. You all are speaking legalese. For me to say I understand the charges gives you all permission to administer the trust.
Okay.
I don't understand the charges.
Which is why you will not.
And I do not need counsel. I don't need representation.
Your request is denied now. You will have representation. All right. Mr. Lebo, do you know what your client wants to do?
Oh my goodness. This is...
the charges?
You cannot make me have an attorney.
Well, actually, I can, ma'am.
Like, this is insane.
Well, I don't think it's me that's being insane.
I can handle my own affairs. I don't need your public defender. All I'm trying to do is get the case settled. That's all. This has been going on for so long. A waste of time and money, honestly.
Mr. Barnett, is there an offer?
There is an offer for the civil infraction and expired.
W001656.
Paul Barnett on behalf of the township.
Assistant Public Defender Davi Liebe on behalf of Ms. Phillips. Ms. Phillips, could you unmute and state your name, ma'am?
You have to unmute, ma'am.
Shannon Phillips, the natural woman.
Lebo, where are we with this, please?
Your Honor, I did have a discussion with Ms. Phillips. I did attempt to explain the importance of representation, why the court has asked that she have an attorney in this matter, as well as conveyed Mr. Barnett's offer. Ms. Phillips indicated to me that she still opposes having an attorney. Additionally, indicated to me that she is not, at this time, wanting to accept the offer of an expired plate.
Well, I think the offer was for a civil infraction of something different.
I believe was the civil plate infraction.
Oh, I see. Okay. All right.
It's improper plate.
What was the offer again, Mr. Barnett?
It was the civil infraction of having an expired plate.
All right, thank you. And not the criminal, not the criminal infraction. Okay. So, Ms. Phillips, that's correct.
So what did we learn from these two sovereign citizen showdowns? First, jargon and paperwork don't override the law. Whether it's UCC filings, talk of flesh and blood identities, or refusing to consent, none of it holds weight in court. Second, judges have seen it all. They won't argue ideology, they'll simply keep proceedings on track. And finally, the harsh truth. Sovereign citizens hurt themselves most. They waste time, risk harsher outcomes, and sabotage their own chances at release. The law isn't optional, and reality always wins. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Trust me, you don't want to miss what's coming next.